Okay, so today we are digging into a really specific and honestly a pretty stressful corner of the property world. We're talking about enforcement.
We are. We've got this source, a guide to using writs of possession from a company called Enforcement Bailiffs Ltd.
And it sets up the scenario that, must be incredibly frustrating. You've been to court, you've won your case, you have a possession order in your hand.
You've done everything right.
Exactly. But the tenant is still there.
And that's the whole point of this deep dive, right? It's about that gap between the judge saying, yes, you can have your property back, and you actually physically getting the keys.
Because a piece of paper doesn't move a person.
Not at all. And what's fascinating is that the reason they haven't moved isn't always, malice or stubbornness. The guide points to this systemic paradox.
The intentionally homeless trap. I read that part and it felt like a total catch-22.
It is.
Are the local councils really telling tenants not to leave?
That's the crux of it. If a tenant packs up and leaves voluntarily, even after a court order, the council can, and often does, classify them as making themselves intentionally homeless.
And if they do that, the council has no legal duty to rehouse them.
Precisely. So the tenant is basically forced to wait for the bailiffs to show up at the door. It's the only way to tick that bureaucratic box that proves they were forcibly evicted.
So the landlord is stuck, not because the tenant is being difficult necessarily, but because of housing policy.
It's a policy-driven delay.
So, okay, the landlord has no choice. They have to call in the bailiffs, and this is where the guide draws a really sharp line. There are two very different ways to do this.
The bottleneck versus the fast track. That's a good way to put it. The default is using the county court bailiff.
These are civil servants, right? Employed by the Ministry of Justice.
Yeah, the guide is clear they're hardworking, but they are just completely inundated, overwhelmed.
The numbers were pretty shocking. It said wait lists of, 13 to 20 weeks in London and the Southeast?
And that's an optimistic figure. It says post-pandemic, it's stretched up to 8 months in some cases.
8 months? That's a huge amount of lost rent.
It's a disaster for a landlord.
So obviously everyone wants the fast track. The guy talks about transferring up the case to the high court. How does that work?
Well, you can't just decide to do it. You need to use a specific legal tool. It's Section 42 of the County Courts Act.
Okay.
You have to apply to a judge for permission to transfer the order up to the high court for enforcement.
And it's not a given. You have to make a case for it.
Right. You need to show there's a good reason for the urgency. You're suffering major financial losses, or maybe there's antisocial behavior, or the property's being damaged. Something that says, I can't wait 8 months for the county court.
And if the judge agrees, you're in a different world of enforcement. But the terminology got a bit confusing here. The guide talks about HCEOs and certificated agents.
Yeah, and that's a really important distinction to make. They are not the same thing. HCEO stands for Authorized High Court Enforcement Officer. There are very few of them, maybe only 50 or so in the whole country.
The guide called them a chief constable, which I thought was a really helpful analogy.
It's a perfect way to think about it. The HCEO holds the legal authority, the writ, from the Lord Chancellor, but they're almost never the person who actually knocks on the door.
So who does?
The people on the ground are certificated enforcement agents. And the key difference is they work in the private sector.
Ah, so unlike the salaried county court bailiffs.
Exactly. These agents are, let's say, incentivized to be efficient. Their business relies on executing these writs quickly. That's why the wait time drops from many months down to just a few weeks.
Speaking of efficiency, there was one little practical detail in the guide that just jumped out at me: the locksmith.
Oh, yes, the locksmith rule. It's so important.
It says the claimant, the landlord, is 100% responsible for providing one.
And it stresses, don't just bring your local handyman. You need a proper professional locksmith.
Because if they can't get the door open quickly, you start getting charged.
You do. It's not just about looking professional. The bailiffs are on a schedule. If your locksmith is fumbling around for more than an hour, the bailiff team goes on a standby rate. I think the guide quoted something like £90 plus VAT.
Per hour.
Per hour. To stand and watch someone fail to open a door.
It really paints this picture of a two-tier system, doesn't it? There's the standard public option, which is, broken. And then there's a premium private option that works, but only if you can clear the legal hurdles like Section 42.
It is. And it sort of forces you to think about the bigger picture. We're essentially using a private system to patch the holes in a public one. And even more than that, the whole system of defining homelessness is actually prolonging illegal occupation.
A system that requires you to be physically, forcibly removed from a home before you can get help finding a new one. That's a heavy thought to end on.
It is. It just shows you. The reality on the ground is so much more complicated than the law on the page.